I like the red sweater, so I like the video. That's right. I came here to compliment the red sweater thumbnail as well. We're still loving that red sweater thumbnail. Why? Because Laura hates it. All right. What's up, everybody? Welcome back. If you weren't here earlier today, we went over that body cam footage from the FBI called in wellness check to Laura Owens' house. Now we're back tonight because our buddy Rob, make sure you say thank you to Rob. I don't know if he's going to be in the chat here. He might still be driving home, but our buddy Rob went up to the courthouse and got us a copy of the official notice of appeal that Laura filed today. So we're going to take a look at that. He hasn't been able to scan in the document, so I just have some pictures he sent me. So it's only about 5 pages, really. So it's not too bad. Let me give it like 1 minute or so to see if anybody else gets in here. Lauren is back on Omegle. They shut down Omegle, man. And no, I'm not. I wouldn't be. That was like a thing when I was like high school age, college age. I said 7. You said 7 what? What's 7? Hold on, I'm changing this title real quick, and then we'll be ready. Okay. That's better. Alright, guys. I said 7 pages. Oh, yeah, okay. Well, technically it's 6 pages, but the last one's just a signature, so we're not going to worry about that. I can't wait for the appellate judges to join our cult. I have hooded robes and a vanilla bean scones for the welcome package. Decorous Aventus, how you doing? All right, let me go ahead and share the screen with you guys. Let me see if I can actually zoom in on this because there's screenshots, not PDF pages. There we go. All right. Can you guys read that? I'm going to try to zoom in a little bit more, but I'm not sure how well it'll go. Just because, like I said, these are pictures, not PDF docs. Okay. Pursuant to, and then there's always a lot of jargon in the beginning of this that I'm going to skip. So, Laura further seeks review of all prior non-appealable and interlocutory decisions. I don't think I know that word. Huh. Orders and rulings by the Superior Court prior to the entry of final judgment. See Motley versus Simmons, explaining in a timely appeal from a final judgment, the appellate court should review any intermediate orders involving the merits of the action and necessarily affecting the judgment, and all orders and rulings assigned as error. Okay. I forgot this is not a PDF, so I have to switch tabs every time I got a new page. And I better close this one. Okay. How's the text looking? Are we better there? Okay. For the appellate court's benefit, Laura notes an obvious issue. The fee judgment does not contain the finality certification required by Family Law Rule 78C, and thus that judgment would ordinarily not be appealable standing alone. Nevertheless, in light of the unfortunately complicated procedural history of this matter, I don't think it's actually that complicated, it is clear the fee judgment is final and properly appealable as a matter of right. This is so because this action involved a single paternity establishment claim, which was tried to the court on June 10th, 2024. On June 18th, 2024, the Superior Court issued a signed written decision dated June 17th, which fully resolved that claim. The under advisement ruling contained a finality certification as follows. It is therefore ordered, pursuant to Rule 78B, Arizona Rules of Family Law Procedure, that this is a final judgment, and it shall be entered, voice crack, and it shall be entered by the clerk. The time for appeal begins upon entry of this judgment by the clerk. Emphasis added. Okay. Laura seeks a change of venue to Levy County, Florida. God. No problem, Kara. Yes, thank you for being here. Okay. Did I finish that page? No. Although the fee judgment entered in this matter on August 19th does not contain a finality certification, and while it does not expressly mention Laura's post-trial motion, that filing nevertheless fully and finally resolved all issues, leaving nothing further for the trial court to decide. Therefore, the fee judgment constitutes a signed written order disposing of the last such remaining motion. This means the fee judgment is appealable pursuant to Arizona Rule blah, blah, blah. Because that rule only requires the entry of a signed written order, not an order certifying the matter as final per Family Law Rule 78C, as the June 18th decision was. So, guys, like, as you guys know, I'm not a lawyer, right? I'm not a lawyer. I'm not a paralegal. I don't work in law in any way. So sometimes when it gets to like jargony stuff like that, or when he's like recapping case outcomes, I'm going to skim through that because I'm just like, there's no benefit to me reading all these letters. You know what I mean? Ida, how are you doing? It's good to see you. Kind of, see you. Whatever you want to call it. Okay. Moving on. Hang on, I need to zoom in on this page a little bit more. Okay. Again, because the procedural history of this matter is confusingly complicated, some additional information is helpful to understand why the fee judgment necessarily resolved Laura's post-trial motion, even though it does not specifically mention it. In addition to her post-trial motion seeking relief under Rules 83A and 85 on July 8th, Laura also filed a notice of change of judge for cause. We all remember that one because that's the "look at me, daddy" filing. The filing of that motion prevented the named trial judge, Julie Mata, from ruling on Laura's, I think you meant Laura's there, other pending motion. On July 18th, while the notice of change of judge remained pending, the notice judge, Julie Mata, issued a one-line minute order purporting to deny all of Laura's post-trial motions. Judge Mata issued this decision despite the fact she was prohibited from doing so by Family Law Rule 6.1. Several days later, on July 23rd, Judge Mata admitted this error, claiming she was unaware of the notice of change of judge at that time she denied Laura's post-trial motion. It has been brought to the court's attention that a notice of change of judge for cause, memorandum, and affidavit in support filed on July 8th before the presiding family court judge, Honorable Rhonda Fisk. So, that was like back then a few weeks ago. I guess it's been more than a few weeks now, no? But like a little while back, it hasn't been that long, she had made that short one-line ruling, and then he was saying, like, this literally doesn't exist because the motion for change of judge hasn't been ruled on, and so she withdrew that motion. And then again, after the notice of change of judge was ruled on, and that was denied, then she was able to rule on that again. So I'm not really sure what the purpose of recapping that is here, unless he's really just trying to rub in the whole shit show. But okay. Hey, Steph, what's up? All right. Okay, and this is more quoting from Judge Mata's withdrawal of that ruling. This court prematurely ruled on petitioner's motion to vacate judgment, motion for new trial, alternatively, motion to alter/amend judgment. That is a fucking mouthful. All right. Unaware of the notice that would suspend the court's authority, let the record reflect the ruling on the motion is hereby withdrawn. Okay. After Judge Mata withdrew her prior order denying Laura's post-trial motion on August 14th, the presiding family court judge issued an order denying Laura's notice of change of judge. This order authorized Judge Mata to rule on all remaining pending matters, including Laura's post-trial motion. 5 days later, on August 19th, the court issued the fee judgment awarding nearly $150,000 in attorney's fees and costs to respondent/appellee Clayton Echard. While the fee judgment does not expressly mention any arguments raised in Laura's post-trial motion, the fee judgment nevertheless implicitly and summarily denied Laura's request for relief, i.e., Laura's post-trial motion raised numerous arguments which would necessarily preclude an award of fees to Mr. Echard if those arguments were sustained, which they have not been at any point, to my knowledge, but okay. Accordingly, by awarding fees to respondent, the trial judge necessarily denied Laura's post-trial motion for relief. Therefore, pursuant to Arizona, and then there's some Rule 9C there, the fee judgment is appealable because it constitutes a signed written order resolving Laura's post-trial motion, which sought relief from a prior certified final order. In the alternative, even assuming the fee judgment was not otherwise appealable, this case fits squarely within the Arizona Supreme Court's rule explained in Barassi v. Madison. Okay. Allowing premature appeals brought before entry of a final judgment. Okay. To be sure, the Court of Appeals has also recognized the Barassi rule as limited in scope. More recently, our Supreme Court reaffirmed Barassi, explaining that appellate courts should dismiss a case for lack of jurisdiction, while a time-extending motion was still pending in the trial court. Here, no time-extending motions remain pending. Thus, despite the narrow scope of Barassi, the law remains clear. Barassi allows a notice of appeal to be filed after the Superior Court has made its final decision, but before it has entered a formal judgment. If no decision of the court could change, and the only remaining task is merely ministerial. Maldonado v. Ashton. Okay. Let's move on over to this one. Sorry, guys, I have to juggle these tabs. Boo Boo Kitty. No one has ever called me that. Okay. Oh man. Hey Brightside, what's going on? Okay. Viewed in full context, it is clear the fee judgment necessarily and finally resolved Laura's post-trial motion by denying all relief Laura requested. But simply, if Laura's post-trial motion had been granted, the Superior Court could not and would not have awarded fees to respondent. On the contrary, it would have ordered a new trial before a different judge, and it would have declined to award any fees to respondent at that stage. I don't understand what he's trying to get at here. And this is another case of like me, I don't know if I'm just confused because I'm not used to reading stuff like this, or I don't know if like what he's saying is really just kind of irrelevant. I'm not sure. Omar will have to explain that one to me. Okay. By doing what it did, the Superior Court made its final decision clear. For that reason, there is no reason for any additional judicial gymnastics in the trial court, nor is there any reason to allow any further time or opportunity to persuade the Superior Court of its error, so that the court's ruling on a pending motion may cure any error and obviate the necessity for an appeal. The trial court has already denied Laura's post-trial motion in its entirety. Then it withdrew that ruling. Then it issued a fee award, which implicitly denied all relief sought in the post-trial motion. Any further proceedings in the trial court to alter this outcome are plainly futile. Accordingly, the Court of Appeals has jurisdiction over this appeal. Okay, then. And that's it, guys. Okay. Fancy Pants, hey, what's going on? I'm a practicing attorney of 14 years. I have no idea what point he is trying to make. Yeah, okay, thank you. That helps. Oh, Patrick. You guys know Patrick. He joined us on a stream one time, and also when we were doing the live stream in court, he was in the chat talking to you guys. Patrick, I don't know if I'll be still doing this because I'm planning on keeping this really short. But I might just like message you to ask questions because I just have personal questions like what the fuck. But yeah, no, I want to keep this one pretty short. I got some stuff I got to take care of before I go to bed. So, but we'll have to have Patrick on again soon for sure, for sure. Okay. The judicial gymnastics quote here is pretty funny, actually. Obviate, thankfully not ovulate. Yeah, that's right. Okay. So some of you guys are talking about the body cam footage from earlier. We got questions about the dumpster here. Could it be more fitting for this dumpster fire? Thank you, Patrick. That was a long-winded and confusing way of telling the court he is filing an appeal. Yeah, that's kind of how I felt about it when I was reading it. You guys ever just read something out loud and it's just like the longest sentence ever and you're just like, oh my god? That's how I felt that entire time. All he said was, it's okay that I'm filing this notice of appeal because laws. Okay. Michelle says that was kind of a letdown. I was hoping for a 30 or so page document. I mean, I think we all are accustomed to that kind of dramatic, manifesto in his filings, but unfortunately, he must be busy with something else. I don't know. I'm assuming he has other clients. All right, guys. Unless you have other questions, that's pretty much it. Rob is going to scan this in for me so that we'll have like an actual PDF, and we'll be able to post that. So you won't have to look at screenshots like this. But this one, I can't scroll through pages right now because I have it in 6 different tabs or 5 different tabs. There's no way he has other clients. I feel like he's got to have other clients, right? He's got to have other clients. My question is, why is it so hot out in September? Dude, I don't know. I haven't gone outside today. It's been raining all day. Like raining hard. Was there really a request for change of venue? No, there was not. No, that would be fucking funny though. Hopefully Boo Boo Kitty doesn't offend you. Look, I mean, I don't care. You're fine. Greg Angel, hey. Hey guys, I just got off work and driving home, so we'll see how long I can stay on. Oh, okay. Didn't they ask for a jury? Yeah, I don't. So that's confusing. He like mentioned somewhere in one of these motions that her right to a jury trial was violated, or something like that. And then, the thing is, like, he didn't ever really say or argue that she should get a jury trial. To my knowledge, he just put that in there. Like it was like he was just throwing shit in there. But I could be wrong. I'm gonna have to go back through those probably. But no, the jury thing was definitely brought up because I was just like, please do this in front of a jury. That'd be hilarious. The Levy County thing was mention of another set of court cases in front of a crazy judge. A crazy judge? Who's the crazy judge? Is this the thing that Megan's been covering? Why do I keep getting a Fiverr ad? I don't know. I said Fiverr earlier, so that's probably why. Fiverr. You're all gonna get Fiverr ads now. Is it normal to announce what you're filing prior to filing? Like, FYI, it's coming. I don't know, but that's how I'm gonna respond to every email from now on. Like, every work email. How would I go about doing that? I'll let you know when I figure it out. You have to request one and pay for it. What are you paying for? Auto reply on email. FYI, it's coming. All the best, Lauren. Okay, yeah. One of those other client is the ripoff report. He's basically their in-house counsel based on my research. Oh, okay. There was $100 written in the minute entry. What's that about? I actually have no idea. I'd love to tell you, but I don't know. Like, I saw that as well, but I have no idea what it's referring to. Maybe Patrick does. Carol says, I would love a jury trial and all the guys along with Dave from Reality Steve get to go testify. I mean, I don't know how a jury trial would go. But yeah. I mean, it would certainly be a spectacle, but also, like, who really wants Clayton and Greg and Mike and whoever else to have to sit through that also? Because you don't know how long that's going to take. Oh, pay the jurors. Okay. Are we sure this was written by Gingras? It didn't have a 20-page copy-paste recap of the trial at the start. I don't know. I mean, yes, we're sure it was written by him, but I don't know. I guess he got tired. Like I said, he must be busy with his other client. So yeah, I am gonna keep this one short, guys. So I keep meaning to do that stream where I show you guys the bus that I stayed in a few nights ago. But I don't think I'm gonna do it right now because I do want to keep this one short. So I'll probably do it tomorrow night. We'll see. And then if there's anything else that comes up that we can talk about, we'll go ahead and do that too. But yeah. Both based in Arizona, and there's tons of articles talking about him representing them. Okay. Grandma Linda, that's true. They changed the rate for his work. Rate for his work? Word salad's probably right. I mean, that's what it read like to me. The jury trial was not asked for, yet Dumb Dingus claims Laura's rights were violated by them not allowing a jury trial. They didn't ask, so how are her rights denied or violated? Good gravy, they suck. Okay, yeah, that's what I thought. And then Fancy Pants, the practicing attorney, says, yeah, you file the notice first, then you either have an in-person hearing or an appeal, just based on paper filing / motions, but his notice of appeal was long and unnecessary. Casey Jimmy, I noticed in Gingras' bar profile he has no liability insurance. That's true. That's true. And Quint says maybe it was $100 to file. Maybe. I don't know. Somebody else up there mentioned there's a filing fee to appeal a judgment. So yeah, she was probably that's probably what that was, I guess. All right, guys, I'm gonna take off because I got some stuff to fix up, and then I want to do a couple things before bed. So. Justice for Clayton, I wish I could answer that question too, but I guess, I don't know. All right, bye everybody. I'll see you tomorrow.